Κύριε εκπρόσωπε του Προέδρου της Κυπριακής Δημοκρατίας, Υφυπουργέ Μετανάστευσης, κύριε εκπρόσωπε Κοινοβουλευτικού Κόμματος, κύριε Πρόεδρε του Δικαστηρίου της Ευρωπαϊκής Ένωσης, κύριε Γενική Εισαγγελέα, κύριε Πρόεδρε του Ανώτατου Συνταγματικού Δικαστηρίου, κυρία Πρόεδρε του Ανώτατου Δικαστηρίου, κύριε Αντιπρόεδρε, κύριοι δικαστές και Γενικοί Εισαγγελείς του Δικαστηρίου της Ευρωπαϊκής Ένωσης, κυρία και κύριοι βουλευτές, κύριοι δικαστές του Ανώτατου Συνταγματικού Δικαστηρίου και του Ανώτατου Δικαστηρίου, κύριε εκπρόσωπε του Αρχηγού της Εθνικής Φρουράς, κύριε Αρχηγέ της Αστυνομίας, κύριε Βοηθέ Γενική Εισαγγελέα, κύριε Γενική Ελεκτή, κύριε Γενικοί Διευθυντές των Υπουργείων, κύριε Αρχιπρωτοκολλητή, κύριε Γενική Λογιστή, αγαπητοί συνάδελφοι, εκλεκτοί προσκεκλημένοι, κυρίες και κύριοι. Με ιδιαίτερη χαρά σας καλωσορίζω στη σημερινή εκδήλωση, η οποία έχει ως θέμα «The Rule of Law Under Strain, Safeguarding Democratic Principles Against Evolving Threats», για το οποίο θα έχουμε την τιμή να ακούσουμε και να αντλήσουμε χρήσιμη πληροφόρηση από τον διακεκριμένο Πρόεδρο του Δικαστηρίου της Ευρωπαϊκής Ένωσης, έντιμον κύριο Koen Lenaerts. Ο έντιμος Πρόεδρος μας τιμά με την παρουσία του, με την ευκαιρία της επίσκεψής του στην Κύπρο και χαίρομαι ιδιαιτέρως που μου δίδεται η ευκαιρία να παρουσιάσω μια εξέχουσα προσωπικότητα στον τομέα της δικαιοσύνης. Το έργο του έντιμου Προέδρου ξεχωρίζει από τη σημαντική συνδρομή του τόσο στον ακαδημαϊκό όσο και δικαστικό τομέα και επιμαρτυρείται από το πλούσιο συγγραφικό και δικαστικό του έργο. Ο έντιμος Πρόεδρος υπηρετεί το δίκαιο ως δικαστής της Ευρωπαϊκής Ένωσης για συνολικά 36 έτη. Ξεκίνησε τη δικαστική του πορεία στο Πρωτοδικείο των Ευρωπαϊκών Κοινοτήτων, το σημερινό Γενικό Δικαστήριο, το 1989. Υπηρέτησε σε αυτό 14 και πλέον έτη πριν διοριστεί ως δικαστής στο Δικαστήριο της Ευρωπαϊκής Ένωσης το 2003. Επιλέγηκε από τους συναδέλφους του για 2 διαδοχικές θητείες να ασκεί καθήκοντα Προέδρου Τμήματος και στη συνέχεια καθήκοντα Αντιπροέδρου του Δικαστηρίου. Στις 8 Οκτωβρίου 2015, ο έντιμος κύριος Lenaerts εκλέγηκε Πρόεδρος του Δικαστηρίου της Ευρωπαϊκής Ένωσης. Ο κύριος Lenaerts απέκτησε πτυχίο νομικής το 1977 από το Καθολικό Πανεπιστήμιο του Λέβεν του Βελγίου, πριν συνεχίσει τις σπουδές του στο Πανεπιστήμιο Harvard, από όπου έλαβε τους μεταπτυχιακούς τίτλους σπουδών Master of Laws and Master in Public Administration το 1978 και 1979 αντίστοιχα. Κατέχει διδακτορικό στα νομικά από το αρχικό πανεπιστήμιο του στο Λέβεν, από όπου ξεκίνησε και την ακαδημαϊκή του καριέρα ως λέκτορας το 1979. Ανελήχθηκε σε καθηγητή του Ευρωπαϊκού Δικαίου στο εν λόγω Πανεπιστήμιο το 1983. Κατά την ακαδημαϊκή του σταδιοδρομία, ο πρόεδρος Lenaerts δίδαξε στο Κολέγιο της Ευρώπης στην Μπρούζ, καθώς και στη Σχολή Νομικής του Πανεπιστημίου του Χάρβαρντ, με την ιδιότητα του προσκεκλημένου καθηγητή. Ο έντιμος πρόεδρος έλαβε πολυάριθμα βραβεία, τιμητικούς τίτλους και διακρίσεις και έχει επιτύχει μια πλούσια και εντυπωσιακή συγγραφική διαδρομή. Κατά τη σημερινή διάλεξη θα έχουμε την ευκαιρία να ακούσουμε για τις τρέχουσες απειλές στο κράτος δικαίου και στις δημοκρατικές αρχές επί των οποίων εδράζεται η Ευρωπαϊκή Ένωση. Θα ακούσουμε για το ρόλο του Δικαστηρίου της Ευρωπαϊκής Ένωσης στη διασφάλιση των κοινών αυτών αρχών και αξιών που υποστηλώνουν την κοινή μας ζωή στην ευρωπαϊκή οικογένεια. Θα καθοδηγηθούμε στην ομολογιακή παρακαταθήκη του Ευρωπαϊκού Δικαστηρίου με αναφορά σε σημαντικές αποφάσεις του Δικαστηρίου επί του ρηθέντος ζητήματος. Θα αποκτήσουμε μια εις βάθος αντίληψη επί του Ευρωπαϊκού Δικαστικού προηγούμενου και πώς αυτό αναδεικνύει, προασπίζει αλλά και ενισχύει τις κοινές ευρωπαϊκές αρχές και αξίες που σήμερα βάλλονται. Θα εδραιώσουμε τη σημασία των ευρωπαϊκών αρχών και αξιών ως θεμελιώδεις και αναπόσπαστες για τα ευρωπαϊκά κράτη-μέλη και τους πολίτες της. Συνάμα θα αφουγκραστούμε τις ανησυχίες και τους στοχασμούς του Δικαστηρίου της Ευρωπαϊκής Ένωσης, όπως αυτοί έχουν αποτυπωθεί στην ομολογιακή του εξέλιξη. Είμαι βέβαιη ότι θα αποκομίσουμε πολλά και σημαίνοντα. Συνεπώς, χωρίς περαιτέρω καθυστέρηση, καλώ στο βήμα τον έντιμο Πρόεδρο του Δικαστηρίου της Ευρωπαϊκής Ένωσης, κύριο Lenaerts. Έντιμε κύριε Πρόεδρε, έχετε τον λόγο.
Thank you. Excellencies, distinguished guests, dear colleagues, dear students, because I know there are students in the room, ladies and gentlemen, it's an honor and a pleasure to be here with you today and to address this distinguished audience. As has been said, I've been invited to talk about the value of democracy within the EU legal order, and the timing for discussing this topic could not be more adequate. It seems to me that democracies fall either because foreign enemies succeed in destroying them, or because they become hollow from within. As for the external threats to democracy, we do not need to look far back in history or far outside the EU to see this. The Ukrainian people, who are fighting for freedom, democracy, and justice against Russian aggression, offer a stark reminder. The war in Ukraine can also be seen as a struggle between a young democracy and an authoritarian regime, much like the stand of the Greek city-states at Thermopylae against the imperial power of Persia, where free societies resisted domination by an empire. As for internal threats, we may look at the fall of the Weimar Republic and the coup d'etat carried out by armed forces in Europe and Latin America. The collapse of the Weimar Republic exemplifies what is now called democratic backsliding, a process in which a political party or movement attains power through democratic means only to erode the very institutions that sustain democracy. Democratic backsliding is not a relic of the past, confined to history books. It is a phenomenon we are witnessing today. In their best-selling book, How Democracies Die, which I strongly recommend you to read, especially for the students in the room, two Harvard professors, Levitsky and Ziblatt, describe with striking clarity how democratic systems can be dismantled by those entrusted to defend them. Unlike coup d'etat that extinguish democracy overnight, these two professors correctly observe that democratic backsliding unfolds gradually, like a flower slowly deprived of sunlight and water. As the title of my lecture suggests, the question that arises is how we Europeans can keep democracies strong, vibrant, and healthy so that they can endure evolving threats brought about by democratic backsliding. To put it simply, how does the EU protect and promote the value of democracy? In order to answer that question, one must first understand the concept of democracy as it is embedded in the EU legal order, and then ask how to protect and to promote it. I will illustrate my suggested answers by looking, you wouldn't expect otherwise, at the case law of the Court of Justice of the European Union. So first, what is democracy in the EU? Citizens must understand how democracy works within the EU legal order so that they can recognize emerging threats and defend themselves against these threats. To begin with, the European Union is founded on the values enshrined in Article 2 of the Treaty on the European Union. Respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights define the very identity of the European Union as a common legal order. And that term was coined in the full court judgments of the 16th of February 2022, the so-called conditionality regulation judgment. Those values stem from the constitutional traditions common to the member states and seek to create, I quote, a society in which pluralism, non-discrimination, tolerance, justice, solidarity and equality between women and men prevail. End of quote. This is Article 2 of the Treaty on the European Union. Like the EU flag, which features a circle of 12 stars on a blue background that symbolizes unity, harmony and interdependence between the peoples of Europe, those 12 values operate as the moral compass that helps Europeans navigate through uncharted waters. They underpin a certain ideal of what the member states and their citizens must strive to become. We Europeans firmly believe that every human being deserves to be treated with equal dignity, whether woman or man, old or young, poor or rich, sick or healthy, foe or friend. This ideal of equal dignity underpins the value of democracy. In the EU, democracy is inclusive. Democracy cannot be equated with the tyranny of the majority. Respect for the value of democracy means that minorities cannot be discriminated against, and that the courts must be strong in protecting the rights of the political minority, even if that protection leads to a negative public opinion. The EU therefore guarantees a democratic space of liberty, where we can love whom we want, pray to the God of our choosing or not pray at all, and live a life without worrying about the color of our skin. Next to being inclusive, in the EU, democracy is composite in nature. On the one hand, representative democracy underpins the institutional functioning and design of the EU by vesting the European Council, and the European Parliament with democratic legitimacy. The European Council and the Council are legitimized through national governments which are, and I quote the treaty, themselves democratically accountable either to their national parliaments or to their citizens. That is to include both parliamentary regimes and presidential regimes in the equation. Whilst the members of the European Parliament are directly elected by EU citizens in free and fair elections every 5 years. On the other hand, national democracies play an essential role in European integration. That is why the European Union is composed of states which have freely and voluntarily committed themselves to the common values referred to in Article 2 TEU, and that is a quote from the famous Republika judgment of 2021. It is in keeping with the value of democracy that a candidate state for membership may join the EU. Similarly, it is in light of that same value that a member state may democratically decide to withdraw from the EU, as the Brexit example shows. In democratic terms, this means that the European Union and national democracies are not in competition with one another, but complement each other, reinforcing democracy overall. In my view, the value of respect for democracy seeks to protect a democracy, a term coined by my Brussels academic colleague, Philippe van Parijs, and that expression was further filled in by a Greek scholar teaching in Oxford, Kalypso Nikolaidis, who has defined the concept as a union of peoples understood both as states and citizens who govern together but not as one. This duality renders the value of democracy composite in nature, making EU and national democracies interdependent. The healthier national democracies are, the more democratic the European Union is, and the more democratic the European institutions become. In turn, the more democratic impetus the EU institutions are provided with, the more EU law improves national democracies. Just like two symbiotic organisms, there is a common interest in protecting the value of democracy as a whole, since that interdependence favors a mutually reinforcing relationship between EU and national democracies, creating these democratic synergies. And third, in the EU, democracy is not only inclusive and composite in nature, democracy is also woven into what it means to be a citizen of the European Union. The status of EU citizenship, which is, I quote a court, intended to be the fundamental status of nationals of the member states, gives access to the democratic life of the EU. That is the title of Title II of the Treaty on the European Union, democratic life of the EU. As an EU citizen, I have the right to vote and to stand as a candidate in European and local elections. In a recent judgment, Commission versus Malta, decided in April of this year, 2025, the court held that by setting up an investor citizenship scheme, which amounted to the commercialization of the granting of Maltese nationality, following a transactional procedure, Malta had failed to fulfill its obligations under the treaty provisions on EU citizenship and the duty of loyal cooperation. In so doing, the Court of Justice sent a clear message to the member states. The member states cannot commercialize the grant of nationality, as this is repugnant to the values on which the EU is founded. EU citizenship is not a commodity. From the perspective of democracy, the Court of Justice is telling that the commercialization of EU citizenship would amount to buying one's way into the EU democratic process, which is fundamentally at odds with the very essence of democracy. EU citizenship should be construed in a way that promotes and protects the integrity of the EU's democratic constituency. In order to have a democracy, you need to have a demos first. As the famous song goes, money can't buy me love, nor should it buy something as profound and principled as EU citizenship. Inclusivity, a mutually reinforcing relationship between EU and national democracies, as well as EU citizenship, help us understand the value of democracy within the EU legal order. However, the picture would be incomplete without examining the relationship between democracy and two other values, namely the rule of law and fundamental rights. This is because one cannot exist without the two other. Together, these values deliver a full, cohesive package. They are interdependent, given that fundamental rights are little more than empty promises where there is no democracy and no rule of law. That it is impossible for a democracy to work properly without respect for the rule of law and fundamental rights. And that the rule of law is devoid of substance without democracy and fundamental rights. That's why we always speak about the triangle: democracy, rule of law, fundamental rights. Democracy thrives only when both EU institutions and member states respect the rules of the game. The political process at EU level works properly only if every actor plays by the same rules, whether they win or lose. Those rules imply that neither the EU institutions nor the member states are above the law, and that it is for an independent judiciary to interpret those rules. Independent and strong courts are important for democracy, as they guarantee that disputes are not solved by violence or intimidation, but by a judge ready to rule without fear or favor. The observance of those rules amounts to upholding the rule of law within the EU. Democracy must operate in keeping with the system of checks and balances established by the treaties. That system is not an end in itself, but a means of protecting individual liberty by preserving the vertical and horizontal allocations of powers laid down in the treaties. As James Madison wrote in the Federalist Papers number 51, and that is a text of 1790, so it's 235 years ago, the principle of separation of powers and that of conferral, Madison spoke about attribution, aim to ensure a double security to protect individual liberty. The EU legal order embraces that approach. Horizontally, the EU institutions must act within the scope of their powers without upsetting the principle of institutional balance. That's the checks and balances principle, the functional separation of powers principle. Vertically, the balance of power between the EU and the member states, as provided for by the treaties, must be safeguarded. That's the principle of conferral. And when it comes to the exercise of powers, the principles of subsidiarity and proportionality. Democracy within the EU legal order requires unwavering respect for fundamental rights. In essence, the rule of the majority must never intrude upon the sphere of self-determination and personal autonomy that belongs to every individual. Certain decisions lie beyond the reach of the political process, safeguarding the very dignity of the human person. The right to private and family life constitutes a paradigmatic example in relation to which the court has held that restriction on the exercise of that right must be limited to what is strictly necessary. And in the working visit this morning with the representatives of the Supreme Constitutional Court and the Supreme Court of Cyprus, we discussed that in more detail. So now that I have sketched out what democracy means, how it is understood in the EU, inclusive, composite, and linked to citizenship of the Union and exercise of the political rights of the citizen, the question now, in a second movement, arises how to protect and promote democracy in the EU. How should we, Europeans, defend democracy? Well, first of all, guaranteeing free and fair elections is essential for the proper functioning of democracy. But obstacles to the democratic process must be removed. Indeed, free and fair elections is the basis. Obstacles to that process must be removed. We'll see in a second movement that it is not enough. For example, in the 2015 Grand Chamber judgment Del Vigne, the court held that a member state may exclude persons from the electoral roll in elections to the European Parliament only if such exclusion pursues a legitimate aim and complies with the principle of proportionality. Indeed, disenfranchising a person should be subject to strict limits. Remember that democracy is inclusive and that everyone in principle must be able to participate. In the United States, there is a big debate about disenfranchising minorities in the framework of the registration of voters. So that is why the Court of Justice of the European Union's case law is very strict on disenfranchising people. In this case, the condition of proportionality was met because the French legislation excluded from the right to vote in the European Parliament elections only persons like the applicant who had been convicted to a very serious crime. In that case, it was a case of murder. Similarly, in Junqueras vs., the court held that a person elected to the European Parliament acquires the status of member of that institution at the time of the official declaration of the results and enjoys from that time onwards the immunities attached to that status. The obstacle, which was the obstacle in that case, was the fact that the elected member to the European Parliament had to swear an oath on the Spanish Constitution before taking the seat in the European Parliament. The court said no, that is not required or cannot be required as a matter of European Union law. The election should suffice to be elected. And more recently, in the important cases Commission against Poland and Commission against Czech Republic, the court held that denying EU citizens residing in a member state of which they are not nationals the right to become a member of a political party infringes EU law. In so doing, the Court of Justice stressed the importance of political parties in the democratic life of the EU. It held, and I quote, "Political parties, one of whose functions is to field candidates in elections, fulfill an essential function in the system of representative democracy on which the functioning of the European Union is founded." So since nationals of other member states can participate in the electoral process for the European Parliament and for local elections in whatever member state where they reside, they must also be able to take part in the life of political parties whenever these elections are at stake. However, as I said, while free and fair elections are essential to upholding the value of democracy, they alone are not sufficient. Democracy must be safeguarded beyond the ballot box by building trust in the democratic process, by engaging citizens, and by ensuring long-term stability and justice. Let's look in these items in turn. So first, building trust in democracy. And that is a huge issue in present-day conditions, as you know, in many of our member states. For democracy to flourish, both at national and at EU levels, citizens must be closely involved in the EU decision-making process. By staying well-informed about the decisions adopted by the EU legislature and administration, they can actively engage in public debate and express agreement or disagreement with the decisions taken. Transparency, openness, and accountability go hand in hand, fostering citizens' trust in their representatives. This openness conveys an idea of democracy where politicians are not above reproach, but subject to criticism so that bad policy decisions can be modified and reviewed. Both the Court of Justice and the General Court held in Access Info Europe and in De Capitani the principles of publicity and transparency are inherent into the EU legislative process. In both of these cases, it was the works of the Council which were at stake, namely the Council not giving access at the time to the identity of the member states which in the legislative process had made proposals for change. The Court of Justice, in line with the General Court's first instance judgment, said no. The identity of the member states must be revealed. De Capitani, a similar holding by the General Court for the workings of the so-called trilogue, that is the conciliation attempts between the Commission, the Council and the Parliament to get a single text approved. And so there also, the identity of who proposed what, both at Parliament level and at Council level, is absolutely essential. Because the right of access to EU documents gives concrete expression to the principle of transparency. It enables EU citizens to exercise their democratic rights and creates these democratic synergies of which I spoke at EU and national level. By having access to the documents held by the Council, the electorate of a member state may monitor the position taken by that member state's government within the Council as an EU institution. And the Council is one of the two chambers of the EU legislature. The same holds true in relation to national parliaments, which are able to check whether the executive has complied with the negotiation position laid down for that executive. The right of access to EU documents, as interpreted by the EU courts, makes it very difficult for a national government to avoid taking responsibility for unpopular legislative acts adopted at EU level, if it is apparent from the internal documents of the Council that that government never resisted the adoption of those acts. In the same way, it cannot take credit for an EU legislative act where internal documents prove that that government consistently opposed the adoption of the act. So therefore, transparency enables citizens to understand and to monitor the democratic process. However, here also, transparency is not enough, given that citizens must also be able to require public officials to assume responsibility for their actions. Whilst the glass-house government is essential for democracy, should a public official fracture its integrity, he or she must be held accountable and bear the consequences. Citizens may hold publicly elected officials accountable either by voting them out of office, by launching a parliamentary investigation, or if need be, by bringing civil or criminal proceedings against them. Accountability is not only grounded in the value of respect for democracy, but also in the value of respect for the rule of law, given that those who exercise public power cannot be above the law. Citizens' trust in the democratic institutions would be called into question if European taxpayers' money was used to fund the interests of corrupt politicians. Put simply, impunity is accountability's worst enemy. From a democratic point of view, this was precisely the context in which the Court of Justice delivered its seminal ruling in Eurobox promotion in 2022, Grand Chamber judgment with the reporting judge, our Vice President. In those joint cases, the Court of Justice held that a series of rulings of the Romanian Constitutional Court had to be set aside, since the application of those rulings had the effect of causing, I quote, a systemic risk of offences concerning VAT fraud and corruption, which were committed by high-level officials, including cabinet-level ministers, going unpunished. That systemic risk of impunity was at odds with Article 325 of the Treaty on the Functioning of the European Union, which requires the member states to ensure that, I quote, cases of serious fraud and corruption affecting the financial interests of the Union are punishable by criminal penalties that are effective and that act as a deterrent. Seen in this light, Article 325 TFEU, which has direct effect, is a powerful tool which gives concrete expression to the values of democracy and respect for the rule of law. Moreover, freedom of the press and media pluralism are vital for a democracy. A free press acts as the public watchdog, enabling citizens to monitor those in power, thereby building trust. And I'm quoting here from an opinion of Advocate General Ruiz Garabo Colomer in the Damgaard judgment. It's a very beautiful opinion. Freedom of the press and media pluralism give concrete expression to the values of freedom and democracy, since those rights are essential to building public opinion in a society that allows divergent views and tolerates disagreements, echoing a society in which pluralism and tolerance prevail, as provided in Article 2 TEU. Because of democratic considerations, restrictions on the freedom of the press and media pluralism are subject to strict scrutiny from the courts. As the Court of Justice has consistently held, the purpose of the press in a democratic society governed by the rule of law justifies the press in informing the public without restrictions other than those that are strictly necessary. In Real Madrid, a Grand Chamber judgment, equally on the report of our Vice President, the Court of Justice was asked to interpret the Brussels I regulation in the context of the recognition and enforcement of a Spanish judgment in France. That judgment provided that the French newspaper Le Monde and one of its journalists had to pay damages to a professional football club, Real Madrid, on the ground that they had published an article suggesting that Real Madrid players were doping, which was found to be untrue. The Spanish court ordered Le Monde and the journalists to pay, by way of compensation for non-material damage suffered, 300,000 euros for the newspaper and 30,000 euros to Real Madrid and to a member of its medical team, respectively. The French Cour de Cassation asked the Court of Justice whether it could rely on the public policy exception or ordre public exception set out in the Brussels I regulation in order to deny the recognition and enforcement of the Spanish judgment at issue, since it was liable to impose an unjustified restriction on the freedom of the press. The Court of Justice held that the recognition and enforcement of the Spanish judgment in France should not give rise to a chilling effect that would deter the press from informing the public about matters of public interest or involving political speech. Whilst press articles that undermine the reputation or rights of others may not go unpunished, no sanction must produce such a chilling effect. Real Madrid is an important contribution to the respect of the value of democracy in the EU legal order, since in a cross-border context, no European newspaper and no journalist must fear destitution because of an obligation to pay compensation exceeding the material and or non-material damage actually suffered by the persons concerned by the article at issue. Moreover, and this brings me to what a famous philosopher Karl Popper called the tolerance paradox, according to which unlimited tolerance must lead to the disappearance of tolerance. As already mentioned, Article 2 TEU states that the values on which the EU is founded seek to create, I quote, a society in which tolerance prevails. But does that provision mean that the EU must tolerate intolerance? Does the EU have to, for example, tolerate views which are rooted in hatred and call for the annihilation of other human beings? In this regard, Popper said, and I fully agree with him, that, I quote, if we extend unlimited tolerance even to those who are intolerant, if we are not prepared to defend a tolerant society against the onslaught of the intolerant, then the tolerant will be destroyed, and the tolerance with them. Of course, needless to say, the challenge in applying that paradox is to know where tolerance ends and intolerance begins. Read in the light of that paradox, I find that the judgment of the General Court in RT France against Council, a Grand Chamber judgment of the General Court, is well-founded. In that case, the General Court dismissed an action for annulment brought by a media outlet that was wholly funded by the Russian state against a council regulation that temporarily prohibited that media outlet from broadcasting content on the ground that it had engaged in a propaganda campaign targeting civil society in the EU, justifying and supporting Russia's military aggression against Ukraine. The General Court reasoned inter alia that the Council had limited RT France's freedom of expression in a way that was in keeping with the Charter, since the challenged regulation pursued two legitimate aims, namely the protection of the Union's public order and security, and the application of pressure on the Russian authorities in order to bring an end to the war, whilst also complying with the principle of proportionality. RT France versus Council shows that in the European legal space, the democratic process must be based on shared norms of mutual respect and a recent debate which revolves around the concept of human dignity. By excluding intolerant voices from the public debate, the EU shows that it is ready to defend the values on which it is founded. Let's now look in a second move to the way of engaging citizens. I told we should first increase the trust in the democratic process as such. How can we engage the citizens? In the EU legal order, democracy is not limited, as I have already said, to electing public officials. It must also incorporate members of civil society into the decision-making. By incorporating such members, EU legislation becomes more transparent and pluralistic. Engaging citizens in the democratic process is essential, for there is no greater threat to democracy than the apathy, that's a Greek word, right? Apathy of those unwilling to stand up for what is right. In her famous book entitled The Origins of Totalitarianism, Hannah Arendt explained the dangers of citizens feeling alienated. Citizens who are detached from the democratic institutions and caught in alternative realities of social media may easily be led astray by the haunting melody of populist siren songs, which seek to dismantle the system of checks and balances put in place by liberal democracies and to replace it by authoritarian leadership. That is why civil society organizations must be protected by law. They help nurture a sense of belonging to a community of shared values and prevent individuals from feeling left behind. That is why EU law also protects the freedom of association enshrined in Article 12 of the Charter of Fundamental Rights of the European Union. In a 2020 Grand Chamber judgment, Commission versus Hungary, the Court of Justice ruled, for example, that the Hungarian transparency law, which imposed obligations of registration, declaration, and publication of certain categories of civil society organizations, directly or indirectly receiving support from abroad, and abroad includes other member states of the European Union, exceeding a certain threshold, was contrary to Article 12 of the Charter. This was because that law imposed an unjustified restriction on the capacity of associations to receive financial support sent from other member states or third countries. From a democratic perspective, two direct implications flow from this judgment, Commission versus Hungary, Transparency of Associations. First, this case sheds light on a new kind of protectionism, one that seeks to prevent the free movement of ideas and civic participation. This type of protectionism is very dangerous for democracy. By preventing funding from abroad, the activities of civil society organizations, notably those that are critical of the government of the home member state, may be severely reduced. Through lack of funding, dissenting voices fall silent, which in turn undermines the quality of democratic debate in the home member state. Second, it is true that increasing the transparency of the financing of associations is a legitimate objective under EU law. However, that objective may not be relied upon in order to establish a general presumption according to which funding that comes from abroad is contrary to the interests of the home member state. Promoting a general mistrust against civil society organizations that receive funding from other member states is at odds with the principle of mutual trust. Public life and public debate in the home member state must be open to influence and be influenced by natural or legal persons established abroad. Put simply, in the EU legal order, civil societies cannot be victims of civic isolationism, since, as Hannah Arendt observed, this prepares the soil for democratic backsliding. And the last element is this long-term stability and justice concern inherent in democracy. Despite what some may claim, the democratic process should not be seen as an enemy of science and expertise. In modern societies where information is crucial, democracy must integrate the perspectives of experts and scientists to ensure that public policies are sound, informed, and rational, serving the common good. The COVID-19 pandemic has shown how easily societies can fall into the trap of epistemic trespassing, when individuals, after a quick internet search or exposure to social media posts, believe themselves capable of solving complex scientific problems. Or even worse, start believing in conspiracy theories. Democracy must therefore be anchored in the pursuit of the truth. The pursuit of truth enabling citizens to exercise their political rights with full awareness of their choices. Experts and scientists should not be portrayed as adversaries of democracy, but rather as essential contributors who foster long-term stability and advance progress through study, debate, and research. Needless to say, those expert views may also serve the common good, in spite of contrary opinion by some. If these expert views are really provided independently and in a way insulated from partisan political pressure. In Commission versus Germany, decided in 2010, the court held that Germany had failed to fulfill its obligation under EU law by incorrectly transposing the requirement that the authorities responsible for monitoring the processing of personal data by non-public bodies perform their duties, I quote, with complete independence, as was required in the then applicable directive. Germany posited that the notion with complete independence did not preclude the Länder, that is the federated states in Germany, supervision, which in turn allowed the government of the respective Bundesland or an administrative body subject to that government to influence directly or indirectly the decisions of the supervisory authorities, or as the case may be, to cancel and replace those decisions. Such supervision was in keeping with Germany's understanding of democracy, as the administration must be subject to the instructions of the government, which is accountable to the parliament. So you see the whole chain of legitimation in a parliamentary system. However, the Court of Justice of the European Union took a different view, holding that protecting those regulatory authorities from influence was an objective pursued by the EU legislature, so as to insulate these authorities from any political pressure when determining whether the processing of personal data complied with EU law. As to the arguments relating to Germany's understanding of democracy, the court dismissed them by holding that independent agencies and democracy go hand in hand. In the key passage of the judgment, the court held, I quote, "The principle of democracy does not preclude the existence of public authorities outside the classic hierarchical administration and more or less independent of the government. The existence and conditions of operation of such authorities are in the member states regulated by the law, or even in certain states by the constitution, and those authorities are required to comply with the law, subject to the review of the competent courts. Such independent administrative authorities often have regulatory functions or carry out tasks which must be free from political influence, while still being required to comply with the law, subject to the review of the competent courts. That is precisely the case, the court said, with regard to the tasks of the supervisory authorities relating to the protection of data." End of quote. So it's a long quote. That line of case law regarding the independence of national regulatory authorities has further been developed in the last 15 years, and most notably in a line of case law, which I will not explain any further, in which our esteemed colleague and President of Chamber Konstantinos Lykourgos acted as reporting judge. In my text you find all the footnotes. This brings me to my concluding remarks for this lecture. Democracy in the EU legal order is inclusive, composite in nature, and woven into what it means to be a citizen of the European Union. Democracy defines the identity of the EU as a common legal order, which strives to protect and promote values that revolve around human dignity. Democracy is not tantamount to the tyranny of the majority, but is about protecting minorities. Democracy respects fundamental rights by ensuring that each and every one of us enjoys a sphere of self-determination that allows us to live a life as we see fit. Democracy is nothing but an empty promise without a rule of law, understood as the system of checks and balances that protects individuals from the arbitrary exercise of power. As John Adams famously said, democracy is a government of laws, not man. Moreover, within the EU, the system of checks and balances has a transnational dimension that can assist national democracies experiencing democratic backsliding in returning to the path of freedom and justice. EU law is by its very nature the law of democracy, as it contributes to building trust in the democratic process, protects civil engagement and long-term stability based on the rule of law. As the case law of the Court of Justice shows, the value of democracy pervades the entire body of EU law. It means that EU law may be relied upon to stop authoritarian tendencies. But most importantly, democracy is a moral choice and a personal commitment. As the famous American philosopher John Dewey once wrote, it is a way of life controlled by a working faith in the possibilities of human nature. At the end of the day, it is for each and every one of us to fight for a strong and vibrant democracy. Civil indifference and apathy are the worst enemies of democracy. Paraphrasing the famous words of Benjamin Franklin, the EU is a democratic union of democracies, if we, Europeans, can keep it. Ευχαριστώ.
Ευχαριστούμε θερμά τον Πρόεδρο του Δικαστηρίου της Ευρωπαϊκής Ένωσης για την εμπεριστατωμένη και τεκμηρωμένη ομιλία του με θέμα «The rule of law under strain, safeguarding democratic principles against evolving threats». Η ομιλία του ανέδειξε με ιδιαίτερη σαφήνεια και βάθος τις προκλήσεις που αντιμετωπίζει σήμερα το κράτος δικαίου και τους τρόπους με τους οποίους μπορούν να διαφυλαχθούν οι θεμελιώδες αρχές που το στηρίζουν. Κύριε Πρόεδρε, η Ρεάλ Μαδρίτης δεν είναι γνωστή μόνο ως μία από τις μεγαλύτερες ομάδες του κόσμου, είναι πλέον γνωστή και ως μία απόφαση, ορόσημο του Δικαστηρίου της Ευρωπαϊκής Ένωσης. Σε αυτό το σημείο θα περάσουμε στη διαδικασία των ερωτήσεων, εν ώψη όμως του περιορισμένου χρόνου, ο Πρόεδρος θα δεχθεί μερικές ερωτήσεις. Θα παρακαλούσαμε οι ερωτήσεις να είναι σύντομες, ώστε να δοθεί η δυνατότητα, αν υπάρχει χρόνος, για όσον το δυνατόν περισσότερες παρεμβάσεις. Μέχρι να εκδηλωθεί το σχετικό ενδιαφέρον και για να δοθεί το κατάλληλο έναυσμα, θα ήθελα να ρωτήσω τον Πρόεδρο του Δικαστηρίου της Ευρωπαϊκής Ένωσης το εξής. Κύριε Πρόεδρε, στην ομιλία σας έχετε επισημάνει ότι δεν νοείται δημοκρατία χωρίς σεβασμό στα θεμελιώδη δικαιώματα και χωρίς κράτος δικαίου. Η κριτική σε όλα τα θεσμικά όργανα, συμπεριλαμβανομένης και της δικαστικής εξουσίας, στο πλαίσιο της ελευθερίας της έκφρασης, είναι πάντοτε καλοδεχούμενη. Ακόμη και η σκληρή κριτική, νοουμένη ότι είναι καλόπιστη και τεκμηριωμένη. Στις μέρες μας δεν υπάρχει αμφιβολία ότι ο λαϊκισμός υπονομεύει το κράτος δικαίου και κατ' επέκταση τη δημοκρατία. Ειδικότερα στα μέσα κοινωνικής δικτύωσης και όχι μόνο, κυριαρχούν μεταξύ άλλων η προπαγάνδα, η παραπληροφόρηση, ο καταγγελτικός λόγος, οι θεωρίες συνωμοσίας, οι ύβρις, οι απειλές και κατασκευάζονται επικοινωνιακού τύπου σενάρια για διάφορους λόγους, τα οποία πλήττουν ανεξέλεκτα θεσμούς και έτσι δημιουργείται μια εικόνα αποσύνθεσης του κράτους δικαίου. Η ανεξαρτησία της δικαστικής εξουσίας, η αμεροληψία, η διαφάνεια, η αιτιολόγηση των δικαστικών αποφάσεων, η δημοσίευσή τους δεν αποτελούν τροχοπέδι στον λαϊκισμό και ειδικότερα σε τέτοιου είδους συμπεριφορές. Κύριε Πρόεδρε, ποιος είναι ο τρόπος αντιμετώπισης τέτοιων συμπεριφορών, λαϊκισμού, λαμβανωμένου υπόψη ότι οι ύπατες επιταγές της δικαιοσύνης και των μεγαλείων της δικαστικής λειτουργίας οδηγεί τους δικαστές να μην χρησιμοποιούν τον τύπο, ακόμη και για να απαντήσουν σε προκλήσεις.
Thank you for this first question, Judge Georgiou. Well, I think the judiciary, first and foremost, should also communicate very transparently. It's one of the policies which the Court of Justice over the past 10 years has followed, that is to make the judicial process transparent so that people can also get trust in that process. So we do now, as you are aware of, we engage in the streaming of our pleading sessions of the Crown Chamber, so that's very important. We also comment on our judgment, that's a recent development, so that we make a small presentation of the cases as we decide them. So I think justice can do a lot to better explain the reasons of its actions. So I know that traditionally it is always said the judges speak through their judgments, and that remains the basic truth. But I think in an era of social media, it is important that the courts be also present. And the Court of Justice of the European Union, one thing, is present on most of the social media to spread its message. Of course, with that policy, which is, I think, a positive development in itself, the judges will not and should not engage in a direct debate with all sorts of criticism on social media, and sometimes also lies and things which are simply not correct. There I think we should stand the heat, so to speak. And if you can't stand the heat, stay out of the kitchen, I always say. So it's a judge should accept this. Also, it's possible that after a judgment, the political process will then again come in action and possibly also adapt the rules. And this can be done to the extent that fundamental rights are being respected. So that's also an interaction between the judicial and the political process, also mediated through a public debate. But the core difficulty of the question you raised is that when we studied the law, and it was also in my case American constitutional law at the end of the 70s, beginning of the 80s, it was sort of, ideas were seen as a marketplace of ideas. Every idea should be countered with a better idea, so to speak. The problem in the social media landscape is that you are now no longer you don't have that marketplace of ideas. So people have their own silo in which they find all the information, and they will only read what they are sort of likely to read and what they like to read also. So it's a complex thing. So it's in fact through the data mining, the social platforms, they know what their different users like to read, and they use the algorithms on the basis of the mined data to know who likes to read what. And so you get into an informational silo where this marketplace of idea paradigma no longer plays to the full. And there, of course, come in the new legislations, like the Digital Services Act, Digital Market Act also, where we try to sort of force a form of, not we, the legislator at union level, to force a pluralism in the social media landscape. And here you see a court all by itself cannot force anything. The legislator can try to do it. And the union legislator is relatively efficient at that, because you see that the President of the United States, he is attacking the European Union because it is regulating the big players on the internet, the giants of the internet, which are mainly American. So it really hurts, so to speak. It's too regulatory. I think it should come from there. And then, of course, judges are again there to interpret this and to make it work and to enforce it. But it's always the interaction between the political process and the judicial process. checks and balances. Also, that is again democracy. But it's a long-run issue to be solved, and it shows that the marketplace of idea paradigm is to be protected. That's pluralism and tolerance. How do we get all these ideas in a single marketplace? And now they are sort of divided silos, one next to another and without crossovers. And that's, of course, to be avoided in the long run, to have a real, what Jürgen Habermas called deliberative democratie. That's the real problem. So judges and politicians together, I think.
Υπάρχει κάποιον ενδιαφέρον από το κοινό? Ο κύριος Τσαρδελής, ο αντιπρόεδρος του Δικηγορικού Συλλόγου, του Παγκύπριου Δικηγορικού Συλλόγου, συγγνώμη, έχει τον λόγο.
Κύριε Πρόεδρε, καταρχάς να σας, εκ μέρους του δικηγορικού κόσμου, να σας ευχαριστήσουμε για την πολύ ενδιαφέρουσα ομιλία, αλλά και για την παρουσία του δικαστηρίου σας στην Κύπρο, της πολύ μεγάλης αντιπροσωπείας του δικαστηρίου σας, η οποία τιμά πραγματικά τον νομικό μας κόσμο. Θα ήθελα να ρωτήσω το εξής. Η ραγδαία εξέλιξη της τεχνολογίας και ιδιαίτερα της τεχνητής νοημοσύνης αλλάζει, μεταμορφώνει τις κοινωνίες μας με πρωτοφανείς ταχύτητες και ρυθμούς. Δημιουργεί τεράστιες ευκαιρίες, πραγματικά τεράστιες ευκαιρίες και την ίδια στιγμή σοβαρές προκλήσεις σε θέματα ισότητας, ιδιωτικότητας και πολλά άλλα. Πώς το δικαστήριο σας προσεγγίζει, πώς προσαρμόζει καλύτερα, αν μου επιτρέπετε, την ερμηνεία του δικαίου της Ευρωπαϊκής Ένωσης σε αυτόν το νέο τεχνολογικό περιβάλλον, ώστε να διασφαλίζει από τη μια τα θεμελιώδη αυτά δικαιώματα και από την άλλη, και αυτό είναι πάρα πολύ σημαντικό κατά τη δική μου άποψη, να μην περιορίζει την καινοτομία, την ανάπτυξη και την πρόοδο από τυχόν πολύ αυστηρή ερμηνεία του δικαίου. Ευχαριστώ, κύριε Πρόεδρε.
Thank you very much. This is, of course, an essential question. It's almost an illustration of what I also replied to Judge Georgiou. As you know, at EU level, the legislature, in the ordinary legislative procedure, that is European Parliament, the Council, on the proposal from the Commission, adopted the AI Act. So that is an act which should sort of regulate and also prevent the ethical pitfalls in which a large-scale use of AI might possibly result. But you see here again, it is a political choice. It's a legislative act. Now, the first preliminary references from national courts have come in. So they just came in the last weeks. So that act starts to live now. So it goes very quickly, and it's always how the development goes. Then, of course, we will have to interpret that act in the light of the Charter of Fundamental Rights of the European Union, and that in a way which is a bit similar to what happened to the GDPR, the General Data Protection Regulation, which is also interpreted against the background of the Article 7 and 8, privacy protection, personal data protection, and then 11, the freedom of expression, freedom of access to information. So we will have similar things, but with other fundamental rights coming in, such as the right to protection of property. Think about copyright, copyrighted material that has been dug up by the large language models, which are underpinning the AI systems. That's already one of the first litigational settings. So I think there are quite a range of problems in the interpretation, application, and enforcement of that EU-wide legislation. It's a regulation, and it's called an act, so which is already interesting as such. It's a regulation, but it's called an act, a law. So it's not even harmonizing national legislation because there was no national legislation. It is simply a new legislation for a new societal problem. So there our court will really play the first role in making that a living truth, that legislation. And it is meant to meet the issues which you were raising. Now, as far as the Court of Justice itself is concerned, because also that is transparency, you can even read it on our website, the court is now developing its own AI brain, which means that we use AI technology available on the market, but we fill it entirely with our own data. So we are not, in other words, dependent on the general ChatGPT or another Perplexity or another sort of worldwide model, which is of course fed by what you can find on the internet worldwide, because there is also, and then through the cloud, which is basically held also by non-EU interests. So all of this is taken very securely and very cautiously. So we work with an own cloud, European managed, and fed with data of our own. That process is now fully in course of implementation. And we have an AI management board inside the court with members of the General Court and the Court of Justice, and of course our engineers and experts working on this in order to make it work. Now, all of this may sound a little bit mysterious, then the question is, what are we going to do with it? What is the objective? Well, it is not to write judgments or opinions of advocates general. The purpose is to develop support for the humans in the loop. And I'm paraphrasing here the book Co-Intelligence of Ethan Mollick, Wharton School of Business Administration, University of Pennsylvania in the US, professor who wrote about the optimal use of AI in different professional settings, also for judges, and especially for a court like ours. We work in 24 official languages. Needless to say, of course, AI can support us in the translation process, in all the combinations needed. It's already largely on the market. So we work with that. But also, in terms of finding more effectively what is written in scholarly writings, in policy documents, in all sorts of documents which might be useful for making opinions of advocates generals, for developing background views in our own reflection. So it's more a matter of research, summarizing texts, improving drafting quality of some texts in some languages, translation support, management. Do not forget that the Court of Justice of the European Union is wholly self-managed. There is no European Ministry of Justice, or a European Attorney General, or a European High Council of the Magistracy, or whatever. So the Court of Justice is a fully autonomously managed institution. So also for the administrative and the management purposes, the AI brain, self-developed, might help us. It's in full progress.
Υπάρχουν ο κύριος Βορκάς.
Ναι. Καλησπέρα σας, καλώς ορίσατε στην πατρίδα μας. Μια πολύ απλή ερώτηση, η οποία όμως πολλές φορές μας απασχολεί. Μέσα από την εμπειρία σας, ποια είναι η εκτίμηση σας γενικά σε σχέση με την εφαρμογή των βασικών ελευθεριών και γενικά του κοινού δικαίου στις χώρες μέλη της Ευρωπαϊκής Ένωσης και ποιες οι εκτιμήσεις σας για το μέλλον?
I'm not sure whether I've seen the gist of the question. So the fundamental freedoms is, of course, if you're referring to the economic freedoms, free movement of goods, services, capital, freedom of EU citizens to move and to reside, there, of course, we are in the sort of hardcore of the consolidated acquis communautaire, which we now call acquis de l'Union, Union acquis. So there I don't see very important new developments. Don't know whether important new developments. We have, of course, the EU citizenship matters, which are still very relevant in our case law, especially when EU citizens move in a non-economic capacity, and then there might be cases about access to social benefits, non-discrimination, and these things. But I would say there, I don't see very big challenges for new directions to be pressed upon us. As we said in the seminar with both Supreme Courts here this morning, the big challenges are now in matters which relate to the area of freedom, security, and justice. It's asylum and migration. It is the civil justice cooperation, like the Real Madrid case, which I mentioned, but there are plenty of others. It's, of course, all that relates to judicial cooperation in criminal matters, the European arrest warrant, the European evidence order, the European proceeds of crime, freezing order, etc. So it's all these aspects which are now center stage. And then everything which relates to the non-discrimination rules, which the European Union has adopted against the background of what you describe, the fundamental freedoms. When you move to another member state, you must have a basic assurance that you will not be discriminated on grounds which are not part of the common understanding of human dignity and freedom of the person to determine her or his own life. So in that sense, yes, but I think on the strict aspect of fundamental freedoms, we have less novel case law now.
Στο βάθος υπάρχει, βλέπω ένα χέρι. Υπάρχουν πολλά χέρια. Και μετά η κυρία...
Ναι. Να σας ευχαριστήσω και εγώ με τη σειρά μου για την εξαιρετική διάλεξη. Απλά θα ήθελα να ρωτήσω, με δεδομένη την αρχή της αλληλεγγύης, όπως αυτή κατοχυρώνεται στη Συνθήκη για τη λειτουργία της Ευρωπαϊκής Ένωσης,
ένα άλλο μικρόφωνο αν υπάρχει. Είναι και θέμα μετάφρασης. Γι' αυτό θα χρειαστεί.
Πώς μπορεί να εξασφαλιστεί στην πράξη μια δίκαιη κατανομή ευθύνης μεταξύ κρατών μελών στη διαχείριση του μεταναστευτικού προβλήματος και επίσης αν το Δικαστήριο της Ευρωπαϊκής Ένωσης έχει θεσμικό και νομικό ρόλο στο να επιβάλλει την αρχή της αλληλεγγύης όταν κράτη-μέλη αρνούνται να συμμετέχουν σε μηχανισμούς μετεγκατάστασης.
Yeah, that's an excellent question. As you know, the principle of solidarity to which you refer and shared responsibility is expressly laid down in Article 80 of the Treaty on the Functioning of the European Union as the overarching principle of dividing responsibility between the member states for the reception and also the processing of requests for the reception of asylum seekers and the processing of asylum requests. So here again, it is the political authorities of the Union, namely the legislature in the ordinary legislative procedure, parliamentary majority in the European Parliament, qualified majority in the Council, all of this on the proposal from the Commission, which adopted the so-called Dublin regulations. And the Dublin regulations provide for a whole set of criteria which, according to which the responsibility over the member states is being divided. It is, of course, not incumbent upon the Court of Justice to call into question these criteria. We must interpret and apply them. And yes, we do deliver judgments from which it appears very clearly that member states cannot simply surrender or sort of give up their responsibility for receiving asylum seekers or for processing their asylum requests when the responsibility in accordance with that legislation falls upon them. But of course, once these judgments have clarified the rules of play and determined the responsibilities of the different member states, it is up to the European Commission to, as guardian of the treaties, as we say, to supervise, possibly after complaints being lodged with the European Commission, and to pressurize the member states to comply with the rules to which the member states have committed themselves, which is the treaty rule, which I mentioned, plus their commitment to respect the legislation lawfully adopted by the EU legislature, as interpreted by our court. So sometimes we do have infringement actions against the member state, but so far, I must say, we had important infringement actions for non-compliance with the trilogy of the triptych, if you want, of reception directive, procedures directive, and qualification directive, which after the new pact will be the procedures regulation, the qualification regulation, and still the reception directive, applicable as of June next year. So there we have, in relation to those instruments, we did have infringement actions brought by the Commission. As to compliance with the Dublin obligations, I haven't seen them. But they could, of course, occur, and then our court would have to find possibly infringements. And as you know, if after an infringement judgment, the member state still does not comply, important financial sanctions can be imposed, which the Court of Justice has done in relation to these other instruments, but not so far in relation to the Dublin regulation. So I think, yes, there are tools, the Court of Justice can act, but we are a court. A court is never of its own motion deciding cases. The court is always reacting to what is submitted to the court. It's what in American constitutional law is called the case or controversy requirement. So a case must be brought and you knock off the cases one case at a time. So in that sense, we are not so different from the common law tradition, which is prevalent in this country. So that's how it works.
Και μια τελευταία ερώτηση.
Thank you, Evaristo. Thank you very much. So first of all, thank you to the Supreme Constitutional Court and the Supreme Court for having invited also the academic community and the students. And also President Lenaerts, thank you for making so much reference to citizens. So this is extremely welcome to see the approach of the President of the Court of Justice of the European Union. So I would like to invite President Lenaerts to maybe come back to the discussion between transparency and openness, to tell us a little bit more about how the Court of Justice of the European Union is implementing open justice, and perhaps to also talk, since we are in the common law jurisdiction, I just initiated it, to make the difference between access to documents and public information and data protection vis-à-vis a wider right to information of citizens, which is a more common law approach. Thank you.
Yeah, thank you very much for this question, which is, of course, a relatively broad topic, but it's an important topic. We have, of course, in our case law, come across the balance to be struck between the principle of transparency on the one hand and personal data protection on the other hand. And I refer here to a case in which I was myself the reporting judge for the Grand Chamber of the Court in 2010, a case known under the name of Marcus Volker und Marcus Schecke and Eifert. It was a reference for a preliminary ruling from the Verwaltungsgericht Wiesbaden, which is an administrative court in Germany, the land of Hessen. Wiesbaden is the capital city of the Bundesland Hessen. And what had happened was there was a legislative act in the framework of the Common Agricultural Policy obliging the member states to publish the names, the first names, the addresses, all the data of the beneficiaries of any form of agricultural subsidies in the framework of the Common Agricultural Policy. So a maximum transparency for the way in which the funds of the Common Agricultural Policy are spent. So transparency, access to information, not so much to documents, but to information. And the member states were not only obliged to make all of that public, but they had to do it on the internet and accompanied even by a search engine so that you could more easily find what you needed to know. So in terms of access to information, I think this is close to what you suggested in common law terms, which I fully understand. It's correct what you said. But of course, on the other hand, two farmers, actually three farmers, Volker und Marcus, his first names, Schecke, and Mr. Eifert, they said, well, we're on that list. We can no longer appear in the local pub. We receive rather little, but we are seen as profiteers, those who benefit, who are living on European subsidies, not working, but financed by the taxpayers all around. And they said, that is not an appropriate balance. Now, the German court asks the Court of Justice, and so you see how the mechanism works. So these people go to the national court, where they ask that their names be removed from the site, internet site, and that the information be, in a way, be made inaccessible. Now that court says, yes, but this is the implementation of two European regulations. These were not even directives, directly applicable regulations. So we need to do what we did. But they found the claim serious. And they said maybe there is a problem at European level, that the right balance has not been struck between transparency and personal data protection. So they ask a preliminary question to control the validity of this legislative act. And the court went about very securely, I think. And this is the 15 judges of the Grand Chamber at the time. The court said you have here two fundamental rights which are in conflict. You have on the one hand the fundamental right of access to information, Article 11 of the Charter. On the other hand, you have the fundamental right to personal data protection. So the court said when the beneficiaries are legal persons, then it's easy. Transparency prevails. Because a legal person has not a right to personal data protection, Article 8 of the Charter, which is only applicable to identified or identifiable natural persons. So all the legal persons, transparency prevailed, access to information. For the natural persons beneficiaries, the court found that the legislature of the European Union had not actually made the balancing, had not applied its mind, if you want, the legislature that is, to the possible encroachment on the right to protection of personal data in a sensitive context for natural persons. So the court said, we quash the rule, we annul it We invalidate it because it was preliminary reference. It's not annulment, it's invalidation, but that's a procedural difference. We invalidate it, and we send it back to the legislature. And the judgment explains that the balancing should take into account the type of subsidies, the amount of the subsidies, the context in which this subsidy is being granted, the type of agricultural exploitation, so to speak, undertaking. All of this should be sort of included in the equation. So the court gave quite a bit of hints to the legislature. The legislature readopted the legislation. That's also a beautiful example of this interaction between the judicial process and the political process. They refined as to natural persons the system. So below a given amount, which is a very low amount, there would be no transparency. Above it, there would be an indication, but the indication would no longer be name-related, but more to the type of agricultural business, to the type of to the size of the agricultural undertaking, so different variables, so that, as you said, it's really the information you need to know without the curiosity to kick at one or another person individually. So it was a new balance. The new text was no longer contested by anyone. But it shows how we work. So if the legislature has not been committed to protecting a fundamental right, which should have been part of the equation, we quash and the legislator has to do the homework over again. And most of the time that works, but not always. After Digital Rights Ireland, where we annulled the, or invalidated there as well, it was also preliminary reference, the data protection, traffic data and location data to be retained by operators of electronic communications, there is still no replacement legislation at EU level. So it works most of the time, but not always. I think this lady.
Ευχαριστούμε πολύ για τις ενδιαφέρουσες ερωτήσεις σας και τις εμπεριστατωμένες απαντήσεις του κύριου Λέναρτς. Ο διάλογος που αναπτύχθηκε ανέδειξε ακόμη περισσότερο τη σημασία του κράτους δικαίου και την ανάγκη προστασίας των θεμελιωδών αρχών σε μια περίοδο έντονων προκλήσεων. Εκ μέρους του Ανώτατου Συνταγματικού Δικαστηρίου και του Ανώτατου Δικαστηρίου θα ήθελα να εκφράσω τις θερμές μας ευχαριστίες στον Πρόεδρο του Δικαστηρίου της Ευρωπαϊκής Ένωσης, τον κύριο Koen Lenaerts, για την ομιλία του στη σημερινή εκδήλωση. Ευχαριστούμε τον Αντιπρόεδρο, τους δικαστές και τους Γενικούς Εισαγγελείς του ΔΕ, καθώς και όλους εσάς για την εδώ παρουσία σας. Σας ευχαριστούμε πολύ.
Thank you.